When would a trial attorney admit a damaging piece of information that could hurt his client's case? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. There are really two instances where an attorney, a trial attorney, is going to admit during the course of trial that his client did something damaging. Now, why would an attorney do that? I'll tell you there are two reasons. Number one, when he has to preserve credibility, and number two, when it will bolster credibility instead of fighting the point. Let's say this is a car accident case, and now it's a question of who went through the red light. It turns out that my client was a passenger. And you know what? The medical records show that he had had a couple of drinks at a bar with some friends before getting in the car. But now my client is a passenger. He did nothing to cause or contribute to this accident. The defense is arguing, hey, this guy got hurt because he was drinking, because he was drunk. And because of that, they are arguing that somehow that contributed to my client's injuries. Now, a good trial attorney is going to turn that around. He's going to take that argument and preempt the defense from using that information. And typically, we're going to do that right in jury selection. Ladies and gentlemen, there's some information that's going to come out during trial that I want you to learn about right now because I need to ask you about it. My client had a few drinks before getting in the car. How do you feel about that, Mrs. Jones? Mr. Gonzalez, how do you feel about that? Now, would your opinions change if you learned that my client was a passenger instead of a driver? Really, how would that change? Tell me, how would that change? Do you think it would make any difference whatsoever if my client had a few drinks and got into the passenger seat? How would that affect your opinion now? And now, what am I doing? I am preconditioning this potential jury to recognize that my client has already done something that I know the defense is going to use against us. So, rather than hide the fact that my client had had a few drinks, and rather than wait until opening arguments where I don't say anything about it, and now the defense jumps on it, and now tries to accuse my client of hiding this great information, what do? I'm the one who brings it out first. I'm the one who wants to tell the jury about it. I'm the one who has the opportunity during opening arguments to let the jury know. Yes, my client did have a few drinks, but guess what? It made no difference whatsoever. So why do I share this quick information with you? I share it with you just to give you an inside look at some of the strategies that trial attorneys use here in New York in accident cases or medical malpractice cases or even wrongful death cases in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. You know, I answer questions just like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.